Hello, everyone. I'm Dan Miskey, partner with Husch Blackwell, and our condominium and HOA law practice is putting on this particular association academy. Before we begin, I'd like to cover a few of the housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. The main one I want to encourage you to use is if you've got questions during the program, if you could use the chat feature. I know there's a raise hand feature. I have no ability to track the raising of hands while we're also doing the presentation, while we're also trying to make sure we give sufficient time to all of the various issues we want to cover. So if you have a question that you want us to answer, please make sure you use the chat feature. A PDF of the presentation is available in the program materials folder. So that would give you access to it. This program has been approved for the CAM ICB credit and legal education hours. We will send you an email tomorrow that will contain a certificate of attendance, sign in for CLE, and the CAM ICB credit, a program survey, and a copy of the recording. That's sort of it for all of the housekeeping issues. So we're going to get the program started. I'm Dan Miskey. I help co-lead our condo and HOA law program. The other speaker, who I'm hoping all of you can see, but maybe not, is Naomi Quayu. She is passionate about going to bat for our clients. She handles litigation. She currently divides her practice between condominium and HOA matters, construction litigation, and disputes regarding guardianships and estate planning. So now we can begin. So as you can read on the first slide here, Association Academy must know Fair Housing Act rules and tactics for winning a trial. If we can switch to the next slide. So the Fair Housing Act, I'm not sure what happened, but my screen went out. So I happen to have it printed here, which is a good thing, but I'm not sure why that happened. So I will just go on, hoping all of you can hear me. You'll see on your screen, neighbor-on-neighbor disputes. You can't just ignore them anymore. And if I were to tell you the number of calls we get that relate to your neighbor-on-neighbor issues, smoking, parking, it sort of covers the full gamut, noise, drugs. It can be almost anything that's neighbor to neighbor, you know, just in some fashion, your neighbor happens to irritate you. And I'm not sure why that is, but that seems to be where most of the issues arise. If we can switch slides. The history of neighbor disputes. I mean, if you will recall, excuse me. If you will recall, for years, we have essentially advised everyone to let neighbors to neighbor disputes work it out between themselves. And that advice was based on the fact that the association had no particular duty that put that on them to help the two neighbors work it out. And it also was based on another thing, which was lots of experience. Neighbors to neighbors bring emotional ties to these disputes. So it does, many times it loses a rational basis of the dispute. The dispute becomes more about winning than it is solving the problem. And that makes it difficult for an association to step into the middle of it. And you'll notice within the slide, I'd said, we are not paid to solve your problems and we don't have to do so. That was generically our position. So if we switch slides and you go to what's changed, and what's changed is the fair housing, and fair housing got involved in HUD. And as you can read, the standards for investigations and adjudications under the Fair Housing Act involving alleged harassment. So it got tied into harassment claims. especially with the bullying. When did this pass? It was 2015 or 2016, just so everybody knows. But it's finally being enforced in the last year significantly enough that in the association, I'm sorry, that at the College of Community Association Lawyers Law Seminars nationally that we went to in New Orleans, we being our condominium law team, so Naomi and I and others, it was talked about more than a little bit, and more than a little bit about how HUD and the FHA is now going to be looking to potentially fine, enforce against associations if they don't enforce, you know, the HUD rules and the Fair Housing Act rules as they've been advanced. So if we change slides. So at the time, the HUD secretary was Julian Castro. And if you take a moment to read what's on this slide, a home should be a refuge where every woman and man deserves to live without threat of violence or harassment. The rule HUD is proposing, that was back before obviously it passed, now passed, is designed to better protect victims of harassment by offering greater clarity for how to handle a claim against an abuser. The answer for how to handle a claim against an abuser, which means there's harassment, is to report it to the manager or board, which puts you directly in line and requires you to end up having to do something. So if we switch slides. The FHA, what it does, it prohibits harassment in housing related transactions toward protected classes. And you notice I just say race, color, religion. Don't worry, I'll list them for you. There's two particular types of harassment that are covered by the application of this rule: quid pro quo and hostile environment. What we're principally talking about here is hostile environment. Quid pro quo we'll also talk about, but it's obvious. I think all of you will go, oh yeah, we kind of knew that, because you should kind of know that that's not allowed. So if we switch slides. This is the rule. It's called HUD's Equal Access Rule. Under, this particular rule, an association is directly liable. So notice it's a direct suit, potentially by HUD against you, but potentially also by the aggrieved homeowner / unit owner / member of your HOA for failing to take prompt action. Prompt isn't defined. And I think we can all imagine that our view of prompt and a unit owner who is allegedly being harassed view of prompt may be two different things. And they would view prompt as within the hour, and we would view prompt as probably within a day or two. But prompt is certainly not a month later. We'll schedule it for a board meeting and talk about it, and then we'll move forward. So there's some options that can take place that we'll specifically talk about. So prompt action to correct and end discriminatory housing practice by a third party, the third party being a different unit owner here, where the person knew or should have known of the discriminatory conduct and had the power to correct it. And we can argue about power to correct it, but you can't argue a whole lot with a condominium association, because the board has the power to do something. And that's really what this seminar is about, is that if you learn of an issue, you must do something. Doing nothing subjects you to potential liability, so don't put yourself in that spot. So if we can move forward to the next slide. This sort of breaks down the rule and what it means. So you're held liable. The harassment is based on a protected class. The protected classes are what we will be talking about very shortly, exactly what they are. In fact, on the next slide, which ones apply. We already talked about race, color, religion. There will be more. The association knew or should have known of the harassment. Oddly, this works in favor of the constant complainer. There's no way you can, each of you have within your associations, I've been involved in this long enough. Each of you have within your associations those people who complain, and who complain more than a little bit. And because they complain more than a little bit, you know who they are. And they constantly complain. Well, it is impossible, next to impossible, for an association to argue we neither knew or should have known of the alleged harassment if it comes from the person who constantly complains about it and has email after email, letter after letter, whatever, text after text, explaining to you how some neighbor of theirs is harassing them. You then have knowledge, and you just can't get away from the fact that you have the knowledge. And then the next one, the association had the power to correct and end the harassment. And I know we talked about it momentarily, and we'll probably talk about it again. But let's just cover basically, if you looked in Wisconsin, and if you're a condominium association and you went under 703.15, which is the powers of the association, and it essentially says it under subsection 4, and exercise any other power conferred by the condominium instruments or bylaws. And those instruments and bylaws almost always give you the power to pass rules. So if you have the power to pass reasonable rules, you have the power to pass reasonable rules that allow you to deal with harassment and discrimination within your association, even if you don't want to. So the other part of those rules that would be relevant for condominiums would be under 703.1651, which defines assessments, and it would include fines. And because fines are included, fines are a legitimate means of dealing with harassment. It's not and shouldn't be your first approach, but it should be kept in your arsenal of things you may need to call upon based on how your progressive fine structure works. So from a good standpoint, this ties right into what we have been preaching for years, which is if you're going to have a fine schedule, have a progressive fine schedule where people put complaints, preferably in writing, that when you receive the complaint, you then deal with it on your progressive fine schedule, which is usually a warning letter first. And then the last one, the association failed to take prompt action. You'll notice that word prompt shows up again. So how quickly do you act? The quicker, the better is going to be my advice. And there will be a case within the next year or two that defines someone having acted too slowly. And the question will be, how slowly is too slowly? I don't know. What's reasonably prompt? I don't know. But you're going to know it when you see it, that it doesn't smell like it passes the test. And it's going to depend on how significant the harassment or discrimination is. Next slide, please. So here is that list of the protected class. You'll notice. And it's pretty simple. When you look at it, it's easy to go, okay, the Constitution lists certain things and Congress may pass other things. And you may have other arguments such as age discrimination. And keep in mind, a lot of the people that live within condominiums and homeowners associations do have age issues. They also have disability issues frequently. You might have race issues, you might have color issues, you might have religion issues. You've got enough different ways, national origin issues. You have enough different ways that problems will potentially arise that you can't just ignore them. And I want to apologize, but I want to combine. We're not going back to the prior slide, so we're staying on this one. But you remember what the prior slide said: protected class, knew or should have known, had the power, prompt. And I talked about condominiums, but I also meant to talk about homeowners associations. Homeowners associations, just like condominiums, frequently have within their powers the ability to pass reasonable rules. Like there are very few associations I've ever seen that did not give the board those types of powers. If you have those powers, you have this responsibility. All right. So if we switch slides going forward up to HUD's premise. And a community association generally has the power, if you read with me, to respond to third-party harassment by imposing conditions authorized by the association CCNRs, covenants, conditions, and rules or regulations, or by other legal authority. I love this sentence. This sentence says to me, not only do we have the ability to write into the documents a fine procedure because of either 703.165 or what the documents say, but we have a duty to use that fine procedure if the warning letter does not work. This will become extremely valuable in front of those judges who go, why are you fining? Why didn't you just do something else? And for those of you who've been involved in this long enough, you know that we have a constant fight with judges who question whether associations should fine, should ever fine, why they fine. It doesn't seem fair that they fine. Now, here's the key. Keep in mind, you can't rely on HUD's rule here unless you fall under HUD's requirements here, which means you need the complaining party to fall under the protected class, and you need the complaining party to be the one filing the complaint. So if the board walks outside and goes, oh, isn't this a shame? They're violating the rules. I'm going to quickly go find them. You are creating your own worst problem because you find them right away. You didn't give them a warning letter. You didn't go talk to them. You didn't do all the things that otherwise we tell you to do, which therefore makes it look like you are discriminating against them. And if they're a protected class, they're going to argue you're the problem of the discrimination. You're going to make your problem worse. On the other hand, if another unit owner sees this violation and it literally does directly affect them in some fashion, you would then have the ability to say, well, if you have a complaint, please put that complaint in writing and the board will promptly address it. And therefore you have the ability to write the warning letter. And therefore, if they don't act promptly to correct the problem, you have the ability to fine them. You've improved your position, but I really want to stress, temper your rush to go, I can go fine, because that's not what I'm saying. With fines, I believe, are effectively required if other methods don't first work. All right, and then the second part of this one, if the governing documents prohibit nuisances, which most of them do, then the association can impose violation fines against the discriminatory owner for causing a nuisance or for failing to do so or do anything, and will result in liability. What I'm really trying to say there is you can use the nuisance provision that's in most of your documents. Some of them say obnoxious behavior, some of it say the language differently, as your means for enforcing the fine. But once again, step one is warning letter of some nature with a reasonable time to correct whatever the problem is. Next slide, please. So the silver lining in all of this, you'll notice I talk about, which is the ability to fine, which we just went through, and the ability of us to therefore use it in front of a court and to explain to the judge, not only did we have the ability to fine, we had the mandatory duty to fine once they did not comply with the warning letter. And the judge is going to say, and on what do you base that? We're going to say HUD and the FDA's rules that now require us to be involved in these neighbor-to-neighbor disputes and require us to act promptly, and specifically reference that part of our ability falls under our nuisance provisions, and that we have a duty to impose conditions authorized by the documents. After the warning letter, the only condition realistically that we can impose that's effective is a fine. Okay, so next slide, please. So the issue becomes, well, how can the FHA do that? And the answer falls under HUD section 808A that says the FHA has the authority and responsibility for administering this act. HUD also has general rulemaking authority to make such rules as are necessary to carry out its powers and duties. Keep in mind, its powers and duties fall under discrimination, which fall under if you harass someone through discrimination, you're violating HUD's rules, and therefore that's how they get to the answer. So you got to start with the stuff I started with, which was a protected class who's being harassed or discriminated against. Next slide, please. So the next slide goes to type 1 quid pro quo. Person subjected to unwelcome request or demand, the this for that. And I give you two elements: unwelcome request or demand, and submission to the request or demand is made a condition related to the person's housing. I give you an example. I am sure your architectural plan will go through if you go out on a date with me. I mean, that's implicit. It's always that way. It's rarely you have to have sex with me, but it's generally sex related. That's why I'm saying quid pro quo. We all sort of know what it's really going for and toward, and that it's wrong. So this is not rocket science on quid pro quo. So if we go to the next slide. This one's the one we've been talking about, hostile environment. These are the two types that we're talking about where HUD is, passed these rules. The person is subjected to unwelcome conduct that is so severe or pervasive that it interferes with the person's right to use and enjoy the housing and exercise rights protected by the FHA. It sounds like it's got this high standard, and you've got to reach that high standard or you have no duty. I would not take that approach, is what I'm telling you. I would take the approach that if they fall under protected class, or you are concerned that they might. So in other words, in every situation, almost, I would look at these factors. Application requires assessment of, and I would literally list these factors on a sheet of paper and go through them. The totality of the circumstances, the nature of the conduct, the context of the conduct, the severity of the conduct, the scope, the frequency, the duration, the location of the incidents, and the relationships of the persons involved. And I would have it all right there. And then I would tell the person who's complaining, please put your complaint in writing so that we have something to present when we have a discussion with the other side, because keep in mind, the other side may also have complaints against the person who's complaining against them. This is not going to, you've dealt with neighbor to neighbor disputes. It is never a one-way street. It is always, they did this, they did Y, they did X, they did Y, and it goes back and forth. And you need to just sort of investigate it and make a decision and enforce something. All right. Next slide, please. So as you look at what I've been talking about and what the rule prohibits, and I should have been more specific, as you can see from the slide, but the sections I've cited prohibit, among other things, discriminatory statements, refusals to rent or sell, denying access to services, setting different terms or conditions, refusing to make reasonable accommodations or modifications, discriminating in residential real estate transactions, and retaliation. Okay. My experience has been that most of these fall under 1, 4, or 5. It's discriminatory statements because someone on the board says something that's inappropriate. And they can say it they can say it in an email that accidentally gets, or intentionally, gets forwarded to the person. The neighbor can do the same thing. The neighbor can send it to the board. They then get sent, to the complaining party as part of a different complaint. It all manages to work its way around. So it's nice if you keep your emails, your texts as professional as humanly possible, so that you later on don't have to go, yeah, I wrote that, but that's not what I meant, because that doesn't carry a whole bunch of weight if you end up in court. Similarly to setting different terms and conditions. Here's an example of one that actually took place. And it was different terms and conditions, arguably. A person had an emotional support animal and wanted the ability to take the emotional support animal throughout the facility as every other person was able to go. And initially your gut instinct is, well, yes, that's the whole purpose of an emotional support animal, just like it would be a service animal. Of course, it's never that simple because they pushed it to the end and said, no, they have to be able to go into the pool with me because I need my emotional support animal in the pool with me. To which then our answer was no, because we contacted the local building inspector and said, if this took place and the animal went in, what would be your position? And their position, at least at the time, was, well, then we're going to shut down your pool because of X, Y, and Z. That made it easy to tell the person you can't bring the dog into the pool. You can have them on the deck 4 feet from the pool ledge, but you cannot have them in the pool because having them in the pool will result in having no pool. That's a pretty easy example, but the examples can become more difficult and harder to find. So arguably different terms and conditions, but different terms and conditions on a basis that is reasonable. So if you're going to have different terms and conditions for people, you need to have a reasonable, logical basis for it that's not based on some prohibited portion of the Constitution. Item 5, refusing to make reasonable modifications and accommodations is pretty self-explanatory, except for the word reasonable. And everyone wants a definition of reasonable, but nobody knows what it is. It depends on the facts and circumstances in each individual case, and therefore you're stuck looking at the individual facts and case and trying to decide what's the right answer. All right, so then next slide, please. Sorry. You get down to 2 types of liability. There's direct liability and there's vicarious liability. The direct liability results, it's pretty self-explanatory. You did something directly that violated one of HUD's rules. You discriminate directly against somebody who's in a protected class. You're going to have direct liability in your association. It's not only you as a board member, you as a person, and you as an association. The vicarious liability is where they get the managers, and the vicarious liability then extends over to the association if what they do is such that you condone the action they took. Now, if they make some criminal action, they come and beat somebody up, that's not going to have vicarious liability 99.9% of the time. There's always odd exceptions. We can move on to the next one. Quid pro quo. Normally sex-based, like we talked about. In exchange for sex, I won't enforce the rules. I won't do something. It's always that type of thing. We can move on to the next. This is where I want you to pay attention. A hostile environment. This is where it's going to matter. For somebody listening to this is going to have this case this year. And it's judged from the standpoint of reasonable person in the aggrieved person's position, meaning the alleged victim's position. What would they reasonably have thought, knowing what they know and having in front of them what they have in front of them? So you can't go as a board, yeah, but I know X, Y, and Z. If they don't know it, it doesn't count. And it said, you can see where I wrote, this is our owner-to-owner issue. As an officer, director, or manager, you must take action to attempt to stop harassing conduct. This actually now is your problem. We don't get to get around it by going it's owner to owner. This becomes, we're going to do something about it. So we'll get to that in another moment. So if we go to the next slide. So I tried to list where I thought you're most likely to see the issues. Unit creates problems for everyone. Could be on both sides of this. The unit owner creates enough problems that somebody then complains about that unit owner, or the unit owner complains directly about somebody else. So that's what I'm saying. The unit owner could be both the person who's in the protected class and the person who's being complained against by somebody else who's in a protective class. What you need is consistent enforcement of the rules, which is why you need a enforcement policy, which is why you need a progressive fine policy. So if you don't have one, get one. so that every time you adopt it, it's warning letter first, small fine, bigger fine, bigger fine. Each fine is viewed from my standpoint daily. I view every day as a new violation. So next slide, please. So how to prevent harassment? This is okay, it's been reported. Step one is what you're doing today. Educate yourselves, educate your managers, educate your board members. Step two is make sure you have an anti-discrimination policy, anti-harassment policy. It should be in your documents. If it's not, pass one so that you can say you were proactive. This is more to be defensive against the HUD claim than it is from a practical standpoint, but it doesn't hurt you from a practical standpoint, so just do it. Then you'll notice I put require all complaints to be in writing. Great concept. But once it's reported to you, even if orally, you got to do something. So even if they don't put it in writing, you then may have to write to them and say, you've reported the following. We've asked you to put it in writing. You haven't been willing to do so. Please do so. But if not, we're going to investigate XYZ. Investigate all complaints, obviously, and then take prompt action, including fining. This is where you're going to have to talk to them.
Sir?
So, yes.
I apologize the interruption, but the slides are not advancing.
Oh, I'm sorry.
No problem.
I may have forgot to advance the slide. So if you can advance the slides to how to prevent harassment.
It should be on how to prevent harassment. Is that what everyone is seeing?
We are seeing the hostile environment slide.
Okay, give me just 1 second. Let me stop sharing my screen and reshare it, and hopefully that will solve the issue.
Thank you.
All right, is everyone able to see the correct slide now, which is how to prevent harassment?
Yes. So this is the one I just went through. I am going to take another second though, because I want everybody to see this. If nothing else, copy this so that you have this when you go into it and have the slides. You know, this is conceptually what you should do. Next slide, please, which is going to be practically what you should do. So 1, listen and pay attention. 2, you have to investigate. You have to figure out what allegedly happened. You're going to have 2 sides to the story. I know that. You're going to have to meet with both sides, explain to the one side what the other side is saying, to the one side what that side is saying. You may have to have a hearing. You may have to talk to your attorney. You know, what I didn't put in here is somewhere between 3 and 4. I would probably send a warning letter to one side or the other if you determined as a board who you felt was at fault, or as a manager who you felt created this situation. So I should have put that in there, which is send the warning letter. Then if you don't get cooperation, correction of the problem, then talk to your attorney. Probably you're going to end up levying a fine. We're going to do it just based on everything we've talked about. And if still not resolved, for sure, schedule a hearing. And this is either in front of the board or in front of your grievance committee. We can do it either way, with the concept being someone has to determine what they've decided the facts are. So it's going to be just like a trial. Both sides put on their case, and the grievance committee / board makes a decision. And then if you have to, at the end, you'll take legal action and seek injunctive relief to stop the one party from victimizing the other party, if that's where you want to go. And I see the questions that are coming in, and we will get to those, but this one I do think is particularly relevant. Sometimes you don't know who, if someone's in a protected class, because it's hard to tell. Agreed. I'm going to make the basic assumption everyone's in some protected class. You could ask them if it's not obvious, what puts you in a protected class, and hear what they say. But that process doesn't mean they'll get it right, yet they still might be in a protected class. Next slide, please. So if the claims are against the board or against a board member, I think this is self-explanatory, but I wanted to make sure you saw it. If it's a board member, You have to just abstain from everything. Don't sit in the room. Don't be the problem, because you're going I should be careful. By don't sit in the room, I mean, you're not going to be sitting where the board sits. You're going to be sitting as the alleged violator and the person who has a complaint against them. If the whole board's accused, then appoint a committee to make the decision and have your attorney do the investigation. But you guys then should step aside and go. And if it's really, you go, listen, I'm happy to resign. Have somebody else run this place. I hate to say that, but we don't know what all the problems are that are going to be caused by this, but we know there's going to be some fallout from this eventually. We will see what it is over the next 2 years. So that's really it for my portion I want to cover. So the key part of this is when you learn of a neighbor-to-neighbor dispute, when you learn of alleged harassment or discrimination, you must investigate. And then the who, what, where, when, why, we've sort of covered with those slides. So next is Naomi, and I will then look at the various chat features. Thank you.
Thank you, Dan. So as Dan mentioned, my name is Naomi Quayu. I'm a second-year associate here at Husch Blackwell. And very earlier on, I had a chance to go to trial and learn about trial preparation and how to successfully win a trial, which I did. It happened about 2 months ago. So I'm excited to share that experience with you all. And also with that trial, we had to involve property management companies and also the board, the board as well. So that's why it's really important to share this and to also talk about what sort of involvement property management companies or board members could have when a trial happens. Next slide. So how do we get here? How do we get to the point where we are now having to go to trial? Typically, a lot of our cases end up settling, or we end up getting a foreclosure money judgment, or we end up getting default because the unit owner doesn't show up. In the 2 years that I've been here at Husch Blackwell, we haven't had a trial. I believe we have had trials prior to that, but sorry, I thought I heard somebody speak. But it's very rare that we would go to trial, and it happened about 2 months ago. How do we get here? So there's a delinquent account. A unit owner fails to pay their assessments, and the association sends notices, and there's still no response, right? So at that point, they turn the account over to Husch Blackwell, and a lien gets filed against the unit owner. And so the lawsuit happens when there's a lien out there, and we're constantly having to contact the unit owner to have them pay their assessments, but they're failing to pay their assessments. And at that point, we file a foreclosure money judgment action with the court. So we end up going to court. If the unit owner doesn't show up, we usually get default, and payment is made thereafter. But in this situation that happened about 2 months ago, the unit owner was refusing to make the payment. They had their own reasoning of why they were making the payment. And at that point, the case goes on to where we eventually have to go to trial. If we're not able to get a win at summary judgment or find some way to settle, then we're eventually going to have to go. We're eventually going to have to go to trial in a case like this. So it happens because the unit owners fail to make full payment. The unit owners refusal to make the full payment, even after we are continuously having to ask to settle the matter. And sometimes opposing counsel also gets involved to where opposing counsel is also unwilling to settle or can't get their client to settle. And we end up having to go to trial. Next slide. So how does this trial stage work? There's a lot of research and writing involved. Also, witnesses are involved, witness preparation, and getting your evidence together. And so one of the things that we have to do is draft trial motions. We have to draft a trial brief. And in this case that we won, we also drafted a summary judgment brief as well. So that takes extensive amount of time to do that. We have a great team of paralegals that help us with when it comes to drafting motions for the foreclosure money judgment. But if we pass that stage, then that's usually when attorneys get more involved with the writing process, and where we're drafting motions, we're drafting witness reports, we're drafting witness testimonies for our own purposes, and we're also drafting trial briefs and summary judgment briefs as well. And specifically with condo cases, there's not a lot of legal research that's involved unless some sort of issue gets raised, and we have to do legal research for that. But usually there's not a lot of legal research that's involved. The law is typically the same, and the statutes are typically the same that we see in most of our cases. And witness preparation takes a lot of time. So with condo cases, the property management companies and also board members are our witnesses. So we have to prep them. We have to draft witness questions and make sure that they're comfortable being on the stand. With some property managers and board members, it might be their first time having to go to court for a trial. So it's a very important part of the process where I have to make sure that whoever I'm putting on the stand feels comfortable and that they're confident in the answers that they're providing. Sometimes we have to arrange subpoenas, and we didn't do that in this particular case that I'm going to get to next. But for subpoenas, there is typically a court demanding for somebody to appear and testify. We didn't have to do that in this case. The property managers and the board members that we spoke to were very involved in the case and willing to testify, so that didn't have to happen. But opposing counsel did subpoena one of the property managers, one of the employees at the property management company. So that's something that you might expect if you go to trial, you'll be subpoenaed to testify. Next slide. So the evidence process, I'm going to get to this probably on the last slide to talk about a key things that the association has to keep up with to help us with the evidence process. Evidence is key. Without that, there's no way that you're probably going to win a trial, because you have the facts, but you also need to have the evidence to back that up. So I had to do a lot of preparation for the evidence, making sure all the notices that were sent out regarding the matter, I had that, and then also everything that all the fines that the unit owner was charged, we had evidence for that. And what really helped me was to prepare a trial binder, and that's something that Dan helped me a lot with as well for the case that we had 2 months ago. Is preparing a trial binder, making sure you have all your witness questions, making sure you have all the exhibits, all the notices, and you have all the evidence for the fines that were charged to the client, and really organize those exhibits so that you can provide it to the court as well. And it also needs to be exchanged with the other party as well. So preparing a trial binder and having evidence is definitely a key to winning a trial. Next slide. So I mentioned a lot of times, I want to talk a little bit about this recent Husch Blackwell trial that we had for a condominium and HOA law team. So it was an action for foreclosure and money judgment. And again, this happened about 2 months ago. We had a unit owner who failed to pay their assessments. And when it was time to pay it, it was already too late because we had already filed a lien against the unit owner. So that's basically the summary of the facts of the case. It seems very simple, but it ended up getting more complicated than that when we look at all the facts that transpired here. So the determinative issue in this case, as simple as it may sound, it was basically whether or not the unit owner made full payment before the lien was filed. The unit owner's point of view was that they left for vacation and they set up an automatic payment system for their assessment payments before they left for vacation, and that the payment portal had a technical issue. That's why the payment wasn't made. So basically they placed all the blame on the association and their payment portal system. So we had to prove that, one, there wasn't an issue with our payment portal system. Two, you did not make the payment on time. And three, we filed the lien prior to us receiving that full payment. And so that's what we had to prove to the court. And there was a lot of pretrial work for that because I had to speak to the property management company. I had to speak to the board association as well. And also do some investigation in terms of what happened with the payment system. Were there any issues? When did the association actually receive the payment? So those are some of the pre-trial work that I had to do prior to even filing the motion for summary judgment. We did end up filing a motion for summary judgment. We did not win on that motion. However, that helped us a lot to figure out what it is that we can show to the judge to eventually get a trial win. In terms of attorney fees expectations, when you're going to trial, the fees are just going to rack up, right? Because we are not only are we having to prep witnesses, we also have to get our trial binder ready. We have to draft motions to the court. So the attorney fees end up racking up in this case. And the great thing is, as confident as I was, I knew that if we win this case, we're going to get all those attorney fees back. It's basically like a breach of contract case. You know, the unit owner agrees that if they fail to pay their assessments, then they will owe attorney fees if we do win on an action for foreclosure and money judgment. So I was very confident going into this, knowing that I had all the evidence, I had my trial binder ready, and I knew that if we were to win at trial, we would get all those attorney fees back for the client as well. Next slide. So in terms of how why this is important for property managers and board members, you guys are going to be key witnesses to a trial. Our property manager, one of the employees with the property management company, was a key witness to this case because most of the communications that happen before a lien is filed goes to the property managers or the board members. So you guys have that firsthand experience with dealing with the unit owner and the history of how they used to make their payments and what really happened with the fines and all of that. So the witness preparation basically is really key. And I had to make sure that I had the proper questions that I wanted to ask the property managers and also the board members. And I had to make sure that they were confident on the stand and how they answered those questions as well. And so property managers and board members have to be prepared to, you know, at some point have to speak have to be a witness at a trial, and they have to make sure that they remember exactly what happened. And I coach them through that, right? I make sure that when they're answering the questions, that they're answering it in a way where it's going to be good for our side and help us win a case. Next slide. So on the trial day, it was very interesting. So this was actually my first trial that I did, and Dan had great supervision over this case, and he really trusted me to just go out there and win this case for our team, and that really meant a lot to me. The trial binder, as I mentioned, was the key. I had all my evidence prepared, all my witness questions prepared. I made sure that my witnesses were ready as well. And you know, with testifying, you can appear in person or virtually. We had witnesses that appeared from other states, and so that was great to be able to do that and to have my witness questions prepared. The evidence that were presented at trial consisted of our notices that were sent out, and what was key was we had to prove that there was no issue with the payment system. And we also had to prove that we did not receive the full payment from the unit owner before we filed that lien. So also investigating the payment system and how it works, and if there have been any issues in the past, that was key. That was a key evidence in this case. And also proving that the unit owner did make payments, but we received it days after. That was also key to prove that. So that goes towards the strength of our position, was that we knew for a fact that the unit owner did not make payment before we filed the lien, and we're able to prove that through the payment portal. We saw that they didn't even attempt to make payment on that payment portal. We saw that they made a bank transfer for that payment, but it was days later that the association received it. So that was the strength of our position, and we were able to show that to the judge. And that right there, I think it shut down the case already at that point. And one weakness that we had to overcome was that there were previous issues of payment system, technical difficulties with the payment system, but we had to prove that those issues were remedied right away, and it did not affect a unit owner's ability to make payment. And we were able to prove that. So opposing counsel used that in a way to show that, oh, you know, they had payment issues in the past, so surely they had payment issues here, and that's why my client couldn't make the payment. But it didn't make sense. You know, there's no way that out of all the unit owners, only your client had the issue making payment when there were any sort of technical issues. We were able to prove that at any point where there was a technical issue, it was remedied, and that unit owner, specifically the defendant, did not have an issue making payment. In fact, there was not even an attempt for them to make a payment. So our request to the court was that definitely the attorney fees. I know that that was one of the client's main concern, was getting the attorney fees back. And also there were fines in this case, and also interest. So those are the three things that I wanted to make sure that we get back for the client. The client at that point was already caught up in their assessment payments, but I wanted to make sure that we get all the interest paid, and also the fines and the attorney fees. And the judge granted it. And that moment for me was super exciting. I mean, I couldn't believe it. I was overfilled with joy. The judge granted everything that we're looking for. And it taught me how to preparation is key when you're going to trial and to win a case. Okay, next slide. So these are my key takeaways for associations. One is maintain proper record keeping of notices. That's what really helped us in this case. As I mentioned, having the evidence really helped us, and having good record keeping of those notices. And one thing that I realized was key was the way that the notices are sent out. And I don't know if it's a requirement to send it with certified mail, but that was really key, because if we sent a certified mail and the unit owner signed it, you're not denying that you did not receive that mail and you did not sign it, unless you want to, allege that, oh, somebody forged my signature. And I think they're trying to say that in this case. But if you are sending notices via email, and also certified mail, and the unit owner is signing it, when we go to trial, it's going to be hard for them to argue against that. And then 2, take action promptly, including fining when appropriate. So here, the fine that we're dealing with was rental violation fines. And we had really good evidence for that, because it was clear that we had reviews from the Airbnb and rental companies. So having that evidence was key. We don't want to just fine unit owners without really having a reason why we're fining them, or without having the evidence of why we find the unit owner. So it was great that this specific property management company and also the association kept really good record of that. And then number 4, ensure that ledgers are always up to date until turnover to the attorney. Then be certain to advise attorney of all payments and communications with debtor. When we have that constant communication, it helps us have, if there are any sort of a miscommunication during trial, it prevents that, right? Because we have a system on our end where we keep track of all the communications that we have, all the payments that we have. So if there's any sort of miscommunication where that is not communicated to us, it can affect us when we're going to trial. And 5, have written communications for each phone call and in-person conversation with the delinquent unit owner. Because we have had some unit owners that will just, flat out lie about a conversation that happened that never happened, or what happened during a phone call. But if there are email follow-up, every time you have a phone call, if there's an email follow-up, hey, thank you, I spoke to you about X, Y, and Z, that would be great, because that is actually something that we can end up using in court, that, and it has all the details of the phone call that happened and all the in-person conversations that happened as well. And 6, be prepared to be subpoenaed or involved in a trial for a foreclosure action. I think that the property management company that we work with in this case, in the association, I don't know if they saw it coming that we'll end up going to trial, and some of them had to testify for the first time. So associations need to be alert. This could happen. We try not to make it happen, and it's rare that it happens, but it is possible, because it happened in this case about 2 months ago. So you just have to be prepared for that. And we will do our very best to make sure you are fully prepared to testify at trial and get a win. Okay, and I think that's it. So we're going to open it up for question now, Dan.
Excellent. So I'm going to jump into a couple of the questions. So I'm
Okay.
reading one that's in the chat. Do we have to assume that if someone has a loud dog or parks close or over the line in the parking lot, that they are doing it because of the aggrieved person's protected class? No. I mean, assuming these are violations of your documents, which I get in some fashion, you would send them a notice that they are violating the rules. If they're going to allege that they're in some protected class, they at least need to make that allegation, or they need to seek a reasonable modification or accommodation. Based on what you've written here, there's nothing that would indicate that. Now, let's keep in mind, if they're getting to their car via a wheelchair, or they have a cane, and it's pretty obvious that they have some disability, you don't get to go, I didn't know, especially if they've been using the same cane for 3 years. So Then the next question I saw was condo and trust. Any effect on the process? No, I mean, within reason, the condos in trust, presumably there's trustees. The trustees are presumably the owner or the beneficiaries, the resident. I mean, at the end of the day, no, the same rules are going to apply relative to what we talked about, which is the FHA rules and the HUD rules are going to apply to the occupant. Let me be careful, resident. You don't have the same requirements relative to a guest. If it turns into a long-term guest, it's kind of different. So the next question, how do you provide proper notice under a progressive enforcement plan for failure to pay assessments when the owner is at an, well, it's failure to pay assessments, so that's the easy part here. So they have already a duty to pay assessments. I'm going to guess these are monthly assessments, and therefore they have a duty to pay, and therefore that duty exists regardless of notice. Now, if this is a change in the amount of an assessment at the beginning of the year, my answer is if they haven't given you an address, the address is the unit. And I would send it by certified and regular mail, and the certified mail will probably come back and the regular mail won't. And there's a presumption under the law then that the regular mail was in fact delivered, because some people can magically make it next to impossible to get them notice. I'm reading on. Failure to pay assessments when the owner is at an unknown place or rehab and the board has no knowledge of the existence of an activated POA, power of attorney, of any kind, or a trustee that may be in place for paying the owner's bills. And the answer stays the same, which is, assuming the judge agrees, my answer is going to stay the same, which is move it forward with the notices that you can give to the location where you know they last were. They have a duty to tell everybody it's advanced, or, you know, where to forward mail or whatever it is. I see it's 12:57, so this could be the last one. But I think it's also the last question. I think I got to the other ones. So can past board members be subpoenaed? Yes. What needs to be in place so they are still protected by the director insurance? You need to make sure your insurance covers both current and past directors. But you have a duty for, if they're being sued for something they did while they were a director, they're going to fall under the Chapter 181 protections, assuming you're a Chapter 181 corporation, which most of you are. And therefore, you're going to have a duty to indemnify and hold them harmless, and your documents probably provide that. So that would be my answer to that one. My God, I think we covered them all. That never has happened before. So I want to thank, I got my duties here, my moderator script, so I will switch to that. So first off, I want to thank everyone for coming. Thank you for joining us today. We hope the information was helpful to you and your organization. As a reminder, this program has been approved by CAM, ICB, credit, and legal education hours. We will send you an email tomorrow, which will contain a certificate of attendance, sign in for the CLE and CAM ICB credit, a program survey, and a copy of the recording. This concludes the webinar, and thank you so much for attending. Have a great day.
Thank you, everybody.
Thank you.